mention?
May it please your lordship. My lord, I beg to mention item number 17 and 18, my lord, of the hearing list.
I'm in 17, my lord.
My friend is for 17, my lord. I'm seeking 2 weeks, my lord. I have some personal difficulty today, my lord.
Connected matters.
Not
No,
connected,
no,
my
my
lord.
lord.
17 is an application under 482, my lord.
Yes.
18, my lord, friends, there. 18 is a criminal writ petition, my lord. Staying for 2 weeks after pujas if the matter can be listed.
My lord, no objection for 17.
17, 18, same order. At the request meet on behalf of the petitioner. This is matter after 2 weeks. Yes.
Much obliged.
Please, Lordship. I beg to mention item number 26, my lord.
Yes.
I beg, pray this matter may come after 2 weeks.
No objection, my lord.
Same order.
Deep obliged, my lord.
Please, Your Lordship, I beg to mention item number 15.
Yes.
Your Lordship, I pray let this matter come after puja break. After 2 weeks, Your Lordship.
Item 15, 1-5.
Yes, Your Lordship. 1
Who is
5.
the petitioner?
Your Lordship. I have no objection, Lordship.
You are applying for respondent number?
3 and 4, Your Lordship. For GHADC.
State is also a party.
Yes, my lord. We are former party.
Just at the request meet on behalf of the respondent number. 3 and 4. Is this matter? After 2 weeks.
After 2 weeks, Your Lordship.
Yes.
Obliged, Your
Much
Lordship.
Lordship.
May I please, Your Lordship? I beg to mention item number 19, Your Lordship.
This is the maintenance matter, my lord,
Yes.
and where where the petitioner have been directed to pay 4,000 rupees to me, interim, and 2,000 rupees to my son, my lord. Ever since they have filed the petition here under 482, my lord, he is not paying at all, my lord.
Is
And
there any interim order passed by this court?
no, my lord, there's no bar, my lord. And the problem now, what is happening there, I've been in touch because this is a legal aid matter. So this lady is so poor, she cannot afford a lawyer there. And she cannot even bring to the notice of the court.
There is no legal aid counsel there.
Legal aid counsel, my lord, I think she is yet to avail,
Let her file an application.
my lord,
Until
yes.
Unless there is stay order.
There's no
why you are
stay
not
order.
paying that? This is not something, it's not good.
And then this issue has been already settled, my lord. Here what happened is that parties belong to the Khasi tribe. Party belongs to the Khasi tribe, and the petitioner was practicing homeopathic in Jowai, my lord. And I am a Khasi lady, but I am permanently residing in Jowai, my lord, mission compound. So in the year 2000, we, with the permission of the family members, my lord, we have cohabited as husband and wife, and a son was born to us also, my lord.
We'll do one thing, since then we'll take up this matter. If that be the thing, if you're not paying maintenance and it's a case of maintenance, what is the challenge here?
The challenge here is the jurisdiction, my lord. One thing, the first is the
Order
jurisdiction.
is passed by which court?
CJM, Chief Judicial Magistrate, my lord. But the
That
Kintu
is in the
yes.
line of the decision of the apex court.
Apex Court, but yes, the Chief Judicial Magistrate, the jurisdiction was raised before her. She took
Because
yes.
the matter is filed in Joy, isn't it?
Jowai is a normal court.
Since both of you are Khasis,
Khasis, yes.
so that is what, as per the apex court judgment, the normal court will have the jurisdiction.
Normal court will have judge. If the residents of the two parties are in different districts, if they are in the same districts,
See,
yes.
belonging to a different district, does it refer to residents?
Res
See, there are.
yes, yes.
If you
There-
go
there's-
deep into the thing,
Yes,
then
my
the
lord.
other thing will come out.
Yes, my
But
lord.
the
It is
only
there.
thing is that the fact remains
Yes.
that both are Khasi scheduled, right?
Both are
Residing
Khasis.
in Jointia Hills.
Yes, yes.
And that view of the matter, Jointia Hills District Council will not have jurisdiction.
Not have a
It will
jurisdiction.
go by the apex court judgment.
Yes, yes. Even in Richard
So,
Singh's
order
case
is passed
also.
by the chief judicial magistrate.
Yes, my lord.
So what is the apparent illegality? There's nothing.
Nothing, my lord. There's nothing.
Yes.
Your Lordship, and I will be seeking instruction, Your Lordship.
No, there is no question of instruction. This is not question. This is a question of law. You have
Yes.
filed the petition. See, if you are not paying maintenance and if you are not paying just because you have filed a case here in High Court, then matter will not be urged.
That is matter may come up, Your Lordship. That is matter may come up of Your Lordship because
Because on the last date also, my lord, my friends were there. We are seeking instructions like, is he paying or not, my lord? And I have taken instruction from the client, my lord. She is not. She's delinquent.
That is what the problem is. See, otherwise, normally this court accommodates so far as prayer of adjournment is concerned if it is not too old matters. But then, if you are not paying maintenance and if there is resistance by the other side,
And now it appears that the petitioner has approached KHADC for divorce. Now, poorly, the lady has been pushed from one corner to another. They've been dragged to KHADC now. It seems he has filed a divorce petition, my lord. And because she cannot afford, so she needs legal assistance in that because she can't do anything.
we'll have it next week.
Next week, yes, ma'am.
much obliged, Your Lordship.
So if you submit in the petition, this matter after a week.
All right.
May it please Your Lordship, I beg to make a mention of item number 13.
Yes.
I humbly pray this matter may be taken up after puja vacations.
Which the other side?
No objection, Your Lordship.
Item 13, 2014 matter. You are making a mention on behalf of?
Mr. Paul. Mr. Paul. He's having some personal difficulties. Lordship.
No objection, Your Lordship.
13.
Lordship, similar.
Made on behalf of Mr. Paul, not the senior counsel, to adjourn the matter on the ground of personal difficulty of the senior counsel. The counsel for the respondent has no objection. Prayer allowed, list of 2 weeks. Yes.
Lordship, similar prayer for item number 16. Item number 16.
Who is item number? Who is appearing item 16? Other side.
For
District council. This is what is the matter about?
106 and 7.
Shifting of these cattle
Cattle.
rearing Gentiles. Now they say that the matter is somehow connected with the matter which is disposed of by part of the division Gauss and Foundation.
So that will cover.
We don't know because they keep on saying it can come after vacation.
They keep on saying those so long that covers them, isn't it?
Lordship, in this case, what has happened is the petitioner had we had sublease, we had leased the land to the government and an animal husbandry department. Now that land has been subleased to the petitioner. If they won our land, then they are willing to do that. Come
What
after
is,
vacation.
what is the prayer made here in this case?
Lordship, they say that there is in violation of the Supreme Court judgment so far as cattle rearing is concerned.
Okay, there are some guidelines by the
Also, there's some problem.
Anyway, we'll have it after 2 weeks then. Same order like before. Okay, just counsel's name is the same. Yes.
May please, Your Lordship, I beg to mention item number 20, Your Lordship.
Item number
20.
20. Yes.
They will come after puja holiday. Your Lordship. I have no
What is your
objection.
instruction, Mr. Abraham? Here
I
in
have,
this matter?
if they are likely to file the FR, so by after 2 weeks, I think I will come to know the clear picture of this case, Your Lordship.
That is why petitioner is waiting. This is also at the request made under the petitioner. Is this matter after 2 weeks? Yes.
I'll pledge. Right, Your Lordship.
May it please Your Lordship, I beg to mention item number 23, Your Lordship. The conducting council is not keeping well, Your Lordship. Let the matter come up kindly after puja vacation, Your Lordship. We are for the petitioner, Your Lordship.
We have no objection.
Same order. Yes, also. Yes.
Highly obliged, Your Lordship.
May it please Your Lordship, I beg to mention item number 24.
Yes.
Your Lordship, the conducting counsel is out of station.
You are appearing for?
Respondent number 2.
I am for the state respondent.
This is also a matrimonial problem?
No, it's not that. The FIR it was filed by the private respondent alleging cruelty and dowry demand. Dowry. She has left and she's not coming.
Yes.
No objection, Your Lordship.
This also the request made on behalf of. So, sir, this is matter after 2 weeks. Yes.
Highly obliged, Lordship.
Highly obliged.
Supplementary cause list, item number 1.
May I please, Your Lordship?
Yes, Mr. Ansar.
Lordship, this is a criminal petition under section 528 of BNSS, Lordship. With the prayer to direct the respondent number 2 to dispose of the appeal pending before the Learned Court of Learned Court of Deputy Commissioner, Tura, West Karo Hills. Lordship, the brief facts of the case is, Lordship, the petitioner herein is the Anti-Corruption League, is an NGO working in West Karo Hills and represented by the petitioner, the General Secretary. The brief facts of the matter is here, Lordship. In the year 2012, the private respondents were started dispute over the disputed land and erected a bamboo fencing in the property.
You are one NGO holding certain plot of land.
Correct, my lord.
Now the private respondent made a claim over it.
Yes, my lord. Yes. And started and fencing over the property. Then, being a general secretary, I filed an FIR on 25/7/2012 before Fulbury PS. And accordingly, the FIR was registered as non-FIR case. Then the matter sent to the Dadangiri in subdivisional officer.
145 proceedings.
145 and 107.
107 also.
107
and 107 and 145 be together.
Most of the cases I have seen, my lord, most of the cases 107 and 145. Yes, my
lord. Not say what you have seen, what the law says.
My lord.
Can it be drawn up by the same?
No, my lord, cannot be. Because 107 came into play only when there is a likelihood of breach of peace.
And what about 145?
145 is a dispute concerning the land and water with regard to land and water.
But there also has to be a likelihood of breach of peace. Until unless there is a likelihood of breach of peace, there cannot be 145.
Yes, my lord. Because why 107 is come into play? Because the law says when both the parties has to enter into a bond, given an undertaking to the honorable court for.
That is when the 107 proceeding is drawn up. See, the parties are asked to execute a bond to maintain peace for a certain period of time.
Yes, ma'am.
Anyway, these are not things. Anyway, just tell us.
Yes,
then what happened? 107, 145.
Yes, my lord. Then, my lord, kindly come to Annexure 3, my lord, at page 29, my lord. The Learned Court of
page 29.
Page 29, my lord. Page 29. The Subdivisional Magistrate Executive Dadangiri, West Karo Hills, accordingly registered a miss case number 38 of 2012, and issue notice to both the parties. And after hearing, this order was passed, my lord.
No. Where is the order by which proceeding was drawn up?
My lord, yes, my lord. This is the final order.
Where is the order by which proceeding was drawn up?
My lord, yes, my lord. Let me come to the issue, my lord. This order was passed on 7/2/2017, and this order was challenged by the respondent number 4 before the Learned Court of Deputy Commissioner, West Karo Hills. This order, my lord, 7/2/2017 order. May I read this order? The operative part.
1997.
Yes, my lord.
Order was challenged by filing a revision.
By filing an appeal, my lord.
Is it appealable?
My lord, that is another subject to, my lord, of discussion. My lord, they file an appeal.
It is another subject of
My
discussion.
lord, the appeal is pending. In that appeal, the Deputy Commissioner, West Karo Hills, has passed the order and stay this order, my lord. And more than 7 years, the
order
appeal
passed in
7/2/2017, my lord. 17.
Yes.
Thereafter, my lord.
Now we are in 24.
4, my lord.
7 years, more than 7 years.
Yes, my lord. The appeal immediately was challenged by respondent, private respondent number 4 before the Deputy Commissioner, West Garo Hills.
Yes.
My lord, next page, page number 30, annexure 4. This is the order, my lord, passed by the Deputy Commissioner.
In what?
My lord, may I read, my lord?
What is where is the case number?
My lord, that is, my lord, they have not given the case number, my lord.
How can it be?
My lord, the Deputy Commissioner has passed this order. The stay of the
Nothing. No,
by this
nothing,
order,
nothing is mentioned.
the order 2017 order was stay and kept in abeyance pending disposal of the
There
appeal.
is also order passed in same month only. Within
Yes,
few
my lord.
days.
Yes, my lord.
It's 2017.
17 only. Now, issue here is, my lord, this appeal is still pending before the office of the respondent number 2, my lord. I filed an application, my lord. Kindly see at annexure, my lord. 5, page 32, my lord. File an application before the respondent number 2 to dispose of the appeal and conduct the hearing, my lord. My only grievance here is, my lord. Yes, my lord. This is an application, page 32.
But then your request is for taking a further hearing of the case.
Yes, my
the
lord.
main case.
Yes, my lord.
Not the appeal.
My lord, the proceeding was closed, my lord.
Where? How do? When? What basis is the proceeding?
My lord, as per the order, my lord.
Where is the
Annexure 29. Sorry, page 29, my lord.
Yes.
Annexure 3. May I read, my lord?
No. Where it is closed? Closure of the.
My lord,
proceeding.
may I allow to read, my lord?
Yes, please. You read it.
Hence, I hereby order under section 145 CRPC that the possession of the disputed land shall rest with the plaintiff. The opposite party shall have no occupation or rent out the area in whole or parts of the disputed land. Any occupation which had come upon thereof is to be vacated by the occupants within a period of 15 days from notice of this order. The opposite party may find a suitable court of law for further perusal, my lord. My lord, this is the order. My lord, as per the instructions, the matter was closed, my lord, before the subdivisional magistrate.
That is, this court has not understood anything. What is this? An inquisition which has come up in the
My lord,
vacated by the occupant.
Yes, my
Now, can this order be passed in 145 proceedings?
My lord,
The 145 proceedings.
Yes, my lord.
Cannot be decided on the merit with reference to the claim of ownership. It's only the possession.
It's only possession, my lord. Yes, my lord.
If even a person without having a title is in possession, then court has to declare possession in his favor.
Yes, ma'am.
Until and unless he disposes the person just 2 months prior to the lodging of the complaint. Now
Yes,
it
ma'am.
is not something very anyway. But we do not know. See, Mr. Who are the parties here?
My lord, parties, my lord. The deputy commissioner and the my lord.
No, this in this case, in this not the parties before the magistrate.
Parties before the magistrate are the private respondent herein, my lord, from respondent number 4.
And then how many petitioners are there?
My lord.
See, your name is not there.
No, my lord,
Anti-corruption, where is that?
my lord, actually, my lord, the Mr. Kabir, my lord, is the general secretary. The land is owned by the Anti-Corruption League, my lord.
Where it is shown
He was
anywhere?
represented, my
It
lord.
is not shown anywhere.
My lord,
It is not shown anywhere. You are not a party before the magistrate.
my lord, the NGO was represented by the
Where do we find it?
my lord, the petitioner, general secretary herein is the party before the magistrate.
He may be a party in his individual capacity.
No, my lord, the land belongs to the land.
No, but then we are going by the name. See, nothing has been seen. There is no elaboration.
My lord, those records may be in the, my lord, subdivisional court, my lord, and the DC
You
office.
have to show us prima facie that you are a party there.
My lord, my only grievance.
It shows that there are 9 names are there.
Yes, my lord.
Then
my lord, my only grievance, our only
NGO, you have only 9 members or what?
No, my lord.
Then?
My lord, these 9 members are the opposite parties, my lord.
No, petitioner plaintiff C, page 28.
Yes, my lord.
And the opposite party, there are 6 persons.
Yes, my lord.
Then?
These are the persons, my lord. Yes, my lord. 1, 2, 3, 2, up to 9, my lord. Yes. Yes, my lord. Number 1 is Mustafa Kabir, my lord.
You were what? Who were you before this thing? You were first party there.
Yes, my lord. First party.
First party means here it is written petitioner plaintiff.
First party means the subdivision.
No, as per what has been reflected here, where you were.
My lord, the first Mustafa Kabir, number 1. This is the.
So you are the petitioner. You, it may be limited thing, but then we will not pass an order. You are stranger now.
My lord.
Yes.
That was exactly my stand, Your Lordship, because initially, even when the court was the case was filed in the court of original jurisdiction, even there he has filed it in his individual capacity. As
exactly, that is what. Yes. Where is your complaint? So the complaint which you filed before police.
My lord, the FIR right now, I have the FIR copy of the FIR is not with me, my lord.
You should have.
My lord,
should
yes,
have. Let us see whether you have in what capacity you have filed the complaint.
Yes, my lord. My lord, at least notice may be issued and record may be called, my lord.
This is, do not know, this is a mess. Which way proceeding has been taken?
Lord,
see, right from the
my
past
lord,
order.
it's a valuable, my lord, the matter is pending for more than 7 years, my lord.
Without recording his satisfaction, drop proceeding under 145.
My lord is correct. My lord, the only
this is your very first order, which was you are saying that in your favor. That is
no,
not, seems to be not tenable.
I'm not seeking for any favorable or my only direction is, my lord, to dispose, my lord.
Right now we are not even satisfied with your local standard. Yes. If you had approached in your personal capacity, things would have been different. Maybe you would have.
My lord.
Yes, Mr. Hava, which way these orders are passed? What orders your magistrates are passing?
Yes. Actually, Lordship, in the order,
can this kind of order be passed? Tell us.
The order has been stayed, Lordship, stayed, and the
even
petition
the stay order, second order also.
Yes.
How an appeal be entertained in 145 proceeding?
Yes.
And see your order, nothing is been
yes,
seen.
My lord. No
whether
number.
It has been registered. What has been registered?
No number, nothing, my lord.
Yes.
We do not know. You see, there are things which requires interference by this court. But then there are problem is that you see there are technical difficulty in that also. We'll do one thing. We'll issue notice. We'll just
yes, Lord.
Yes.
You take instruction. Yes. We are issuing notice only for the purpose of enabling you to take instruction. How yes, these orders can be passed.
Yes.
Without like adherence to the basic provisions. Can matters be conducted like this?
I'll have to seek instructions with regards to that.
Mr. Hassan. Mr. Hassan, think over this court is not very much satisfied about your locus.
My lord,
think over the matter and take.
Yes, my lord. I'll.
I'm not sure whether this case.
Issue notice. Returnable in 3 weeks. Mr. Thava, APS for respondent number 1, 2, and 3. Isn't it?
Yes. Yes.
That's correct?
Yes, Lord.
Petitioner shall take step for service of notice upon respondent number upon the private respondent number
4 to my lord 9. 4 to 9.
Within 2 days. Least after 3 weeks.
Right.
See, you should have prepared it carefully. You have not even prepared it carefully. There is illegality down below, and now your thing also. You have not taken care of it.
My lord, I'll.
Yes.
Hello, bless.
All right.
Daily cause list, item number 1.
Yes.
Your Lordship, kindly grant us 3 weeks time to file the service
Who has
affidavit.
entered appearance on behalf of
Lordship,
respondent?
I'm entering appearance for number 2, my lord. Respondent number.
So that is you were awaiting that one only.
Yes, my lord. Yes.
So that way that is not required for now them.
Yes.
What is the matter about?
Lordship, I've received a 5-minute briefing today morning. What I understand is that I had filed an FIR against petitioner. FIR was registered under various sections, including fraud, forgery, etc. He approached this honorable court for 2 reasons. One, seeking bail. Bail has been granted, anticipatory bail. Number 2, for quashing of FIR, which is before my lord. So this
Anticipatory bail cannot be granted by this court?
no, by the other bench.
Yes.
By the other bench.
So 2 separate applications.
2 separate applications. That is closed. That is disposed. What is pending, my lord, is this quashing petition.
Okay. So you intend to file an objection on this matter?
Yes, my lord, with lordship's permission.
Of course, this will be optional if you do not want even.
Frankly, my lord, I'm yet to go through the petition, but if lordship allows, I'll file.
No, that is up to you. If you want to file, please not, because there will be certain environments
Absolutely.
you may have to refuse.
Absolutely.
Okay. Mr. S. Jindal, Learned Counsel. Oh, just say, just before that, you say, in terms of the order dated 38/2024, the petitioner has not filed any service affidavit in support of service of notice upon the respondent to stop. However, Mr. S. Jindal, Learned Counsel, has entered appearance on behalf of the respondent number 2 today, and hence there is no further requirement for the petitioner to file any service affidavit as ordered earlier. Then you give paragraph as paid for by Mr. Jindal. Two weeks. How much you got?
2 weeks. 2 weeks.
2 weeks time. Is granted to the respondent number 2 for filing an objection in the matter.
Respondent number 1.
You'll be filing objection. Your state. So you will just see what happens.
Yes, sure.
Yes. List accordingly.
Item number 3.
Lordship, these are the connected matters.
3 to 12 is a connected matter.
Yesterday, my lord, we have filed an affidavit against a rejoinder against affidavit filed by state.
State has filed affidavit in item number 3, that is a lead matter. And we have received affidavit in respect of number 4, serial number 4.
So what we've done, my lord, is that we filed our affidavit in number 4.
State has filed what common affidavit for all the
For all of them. Similarly, we have filed a common rejoinder for all. Rejoinder, my lord, has been filed in item number 4, that is WPC 175.
175.
Item number 5. 4, sorry.
175?
Yes,
my lord.
What about 174?
My lord, so
My lord, state has
that is
filed
the
in
leading
one.
case, isn't it?
My lord, yes.
My lord, because problem is, my lord, most of these officers are spread all over the state.
Okay.
It becomes difficult to.
So pleading is complete.
No, my lord. What remains, my lord, is because the private respondents also have filed their affidavit. We need to file a small rejoinder against that. Also, about 2 weeks, maybe. Kindly granted, my lord.
Just yes. Mr. S. Jindal, Learned Counsel, let me for the petitioner submits that a rejoinder affidavit
Oh,
to the affidavit in opposition
they have filed a rejoinder, that's it.
filed by the state respondent
Yeah, fine.
has been filed in WPC number 175 of 2074.
So
No, private respondent rejoinder we have not.
And praise and submits that the same may be taken as a rejoinder affidavit for all the related cases.
My lord.
That is all right?
My lord.
The Learned Counsel prays for grant of some more time for filing a rejoinder to the affidavit in opposition filed by the private respondent.
We filed in here.
How long will be needing?
2 weeks.
We are allowed list of 2 weeks.
Obliged.
You have received rejoined?
Yes, we have received.
Or Lordship, if can come for admission hearing, Your Lordship, because we are raising the plea of maintainability of the old petition, Your
In
Lordship.
this court, you do not have to list anything for admission here. It will come up, even if it's the last time of hearing, also it will come up. So there is no problem here.
Lordship,
Let the pleading be completed. Then we'll.
Lordship, yes. Then ask.
Grateful, man. Obliged.
Apply, Your Lordship.
Common order in all.
3 to 12, Your Lordship.
3 to 12.
Lordship. Apply, Your Lordship.
Hearing item number 14.
Yes.
My lord, on the last few orders, the state has stated that they will give some statement regarding the compensation.
Is it?
I'm
Yes.
appearing on behalf of the
Where-
district council. Your Lordship.
Where is that order? What is the order dated?
Order dated 8/8/2024
8.
of August 2024.
Yes, where is Mr. Hazarika?
He was here just now.
Yes, Mr. Abram.
Yes, Your Lordship, and this has been led by this H. Hazarika.
You see, probably this is a case. It is only because of your submission advance on behalf of the state. Otherwise, there is nothing much in the writ petition. But then a submission came from the government advocate that some compensation has been paid to some persons. Now we want a detail of that. Now from 8/8 now, it has not been. Yes, Mr. Hazarika.
May I please, Your Lordship, that I have to receive some of them we have already paid the compensation last time Your Lordship has said.
And what about these petitioners? You are admitting their claim, it means.
No.
Why?
No, because those we have encroached right of ways, that portion of land we have paid.
Does your affidavit say that?
Yes.
What is the difference between this person and those? How do we differentiate it?
No, differentiate between some position, my lord. There is zigzag way, so make it straight. So it is across the right of ways, and
Yes.
their land
Are you
is.
ready for the hearing?
No, my lord. If the state is giving the record of the compensation which they have paid to the some of the people, then let them file the affidavit through affidavit.
Now, is this case connected to that ADB road project?
Yes, my lord.
And you say that you have a land there.
Yes.
They are not actually, that is, they are asking this Aking land, but there is no which position they have encroached this and that, there is nothing is
So,
there.
see, Mr. Hazarika, probably petitioner had no case till you made a submission that some compensation amount has been paid.
Yes.
Now you have placed on record and it says that yes, some amount has been paid. Now we'll have to examine what is the extent of their claim. If they are entitled, you have to pay them.
Yes, they are not entitled because their land we have not encroached. We have not taken also.
That is what we have to see.
Yes, yes.
You have paid for some because your stand What is your stand in this case?
No, here our stand is that that compensation is paid where in which place we have crossed the right of ways.
Let us come to your affidavit. Please, let us see.
Okay, my lord.
Where is your affidavit?
Affidavit here.
This is affidavit filed on behalf of response number 2 and 5. Is it the affidavit?
Yeah.
Filed on 21st March 2017.
Affidavit in opposition. Yes, my lord.
How many affidavits you filed? State. How many affidavits have been? Who is respondent number 3? You are the district council. Now, what role you have played here? In a land acquisition process, in what role you have to play, madam? You have filed affidavit also. See, Mr. Hazarika, come to your paragraph 3, page 3 of your affidavit.
Yes, my lord. That the answering deponent before awarding the content of the writ petition are back to submit that low land acquisition process has been taken place. However, it is stated that the state respondent take the initiative to improve the existing road under the project of ADB land road from Garbada Ampati Mahindraganj Purakhasiya Dalu Road, and as such the instant writ petition does not survive and liable to be dismissed. In respect of the land, we are telling that in respect of the land of the petitioner, my lord.
No, you are not saying in the respect of this thing. What is the language here?
No, I understood.
No land acquisition process has been taken place.
Yes.
So that is what you will be answerable there. This part.
For
you have made a false statement here.
Yes.
You have made a false statement in your affidavit.
Because we have filed the affidavit in opposition in response to the petitioner, my lord. So
that means you can say that no proceeding has been initiated.
No,
just because it is. See, you cannot cover up by saying this. That is. I don't think that. Anyway, this court will interpret these things.
Yes.
We'll have to answer this.
Okay.
Yes. When thing will be this thing, because here your communication it's clear. Payment of compensation for land and so and so. If you have not drawn up any proceedings, how you have paid a compensation? Your officers will be answerable. They will have to answer. See, it says on approval of award from Revenue Disaster Management Department by the RDN number so and so, and your affidavit is no long execution proceedings. It is not a statement that you say that the petitioner doesn't hold a land there. That is a different thing. Could have been a different thing. You say your statement is clear, so we are to submit that no land acquisition process has been taken place. Yes, madam. When can it be taken up?
My lord, if you kindly grant them to file the affidavit through affidavit which they have.
We'll tell them to give you a copy of this. If affidavit is required, then we'll ask for it.
Okay, ma'am.
Because after this, probably they will have to file some personal affidavit, these officers.
Okay, madam.
This court will definitely take serious note of that.
Yes,
So instead of doing it right now, we'll see which way hearing goes, and accordingly I will file it.
Okay, ma'am.
Okay, because if any wrong statement is made, then they are answerable for that. Okay, they cannot do it. It is only because of the submission of the government advocate we came to know this. This is nothing, no disclosure about. in the affidavit. It's totally different. Your statement is very much clear. You say that law acquisition process
Yes, my lord.
was initiated because
Yes.
kindly let us finish. Because your improvement was within the area called ROW.
Yes.
But then here you say you have paid.
No, some question they have encroached, so they have gone beyond this right of ways. So that portion they have.
Can you pay it without drawing up proceedings?
That is they have.
That is what we will see. We will verify on how on what basis you have made this payment. Right. Because otherwise your affidavit, if you go by your affidavit, they do not have a case. Because you say no, we have only made the improvement work within the limits.
Here, most probably, my lord, this respondent authority are meant to for the in respect of the petitioner. That wording is missing here.
That has become the basis of this.
No,
Otherwise, this court was basically, after hearing them, would have dismissed it. Only accept your submission. Your submission has basically changed the whole thing.
Yes, my lord. What is the fact? So I have
you
submitted.
said that some compensation has been paid.
Yes.
That is. Otherwise, nothing. Your affidavit doesn't say that some compensation has been paid.
On that one, there is some.
That is
there is some bona fide mistake, my lord. They're supposed to mention, but it has not mentioned.
The learned Mr. H. Hazarika, the learned state counsel, submits that he has received Mr. Hazarika submits that he has obtained instruction from the state respondents in terms of the order dated 8/8/2024 passed by this court. Learned counsel, the Learned State Council has placed on record a copy of the instruction received by him before this court. We'll file it by an affidavit. Will it be proper?
And that is if honorable court is rejected, so I have filed.
And the
In fact, it is not required, my lord.
why? So we'll see to it. Just what you say? Yes. Okay. Like a copy of the instruction. You have a problem to supply it to them?
Oh, yes, my lord. That what instruction I have got. Yes, my lord. There's no problem. I can give one. Yes, I can give.
You can supply a copy, isn't it?
Yes.
But it will be proper on your part. Anyway, you do one thing. We'll just see. When can you be this thing?
After 2 weeks.
After 18 October, my lord, because I will be out of station.
Okay, we'll have it after 3 weeks then. Yes. Give a paragraph. MS Marak. Yes, sir.
Yes, Marak is my lord.
Sir, Marak. This court forgets the name, you see. Sir Marak, learned counsel for the petitioner. Praise for grant of some time. As the conducted counsel for the petitioner is not available. Prayer allowed. List after 3 weeks. Think about Mr. Hazarika. Just I do not know which way that has been done, but then it should not be something like that. You see, like
yes, it is there, my lord.
End up in trouble for
Yes,
filing false evidence.
yes, my lord. What I have realized, it is they have met.
Otherwise, this court was not at all in a mood to entertain the thing. See, the claim of the petition. There was nothing. Hardly tell you thing.
Yes.
Item number 21.
Yes.
Lordship, I would like to apologize at the onset, my lord. It seems I am having some technical problem with my Wi-Fi. If my lord can accommodate me, I'll appear in person on Monday, my lord.
Yes.
If it's okay with this court.
You are appearing for? Along with Mr. Shilla.
I'm just for the respondent number 1, your lordship.
After 2 weeks?
If it's possible this Monday, my lord, I actually am ready, my lord.
See,
Monday
we do not know how the situation will be next week. So.
Oh, okay, my lord. Okay.
Because.
Okay, my lord. Whatever is convenient for this court, my lord.
No, if you want, we can keep it, but then you can give a try, but then may not be a problem.
Okay, my lord. Yes, can you list it then, my lord? If my lord can take it, well, good. If not, then.
Shilla, learned counsel appearing for the petitioner. Please for grant of some time on the ground of his personal difficulty. The prayer has not been opposed by the learned AG. Appearing for this prayer allowed, list of 2 weeks. Yes.
Item number 22. Item number 25.
Yes.
Yes, Your Lordship. So this is a prayer for quashing on the basis of settlement. Lordship, I'll take straight away to the FIR which has been filed. Lordship, may I have page 14.
Page 14, yes.
1-4. If I may just read, Your Lordship. Respectfully, I, the undersigned, would like to state that on 6 September 2019, around 7 p.m., while I was proceeding my vehicle from the Nongkram to a Light Court, reaching Light Court, a sharp turn, suddenly one motorcycle bearing ML05J so-and-so came from the opposite direction in rash negligent manner and dashed against my vehicle, resulting which the vehicle got damaged. However, I did not report in time as they wanted to compromise the matter. But on 9 September, I got the information that the pillion rider of the above motorcycle got expired, and so I'm giving this FIR for my safe side. Hence, I request you to kindly do the needful.
Expired because of the accident.
Because of the accident.
Injury received.
Yes, Lordship. So the pillion driver who was sitting with me, the petitioner, had expired because of this occurrence. Now, on the basis of this, Your Lordship, charge sheet was filed. Charge sheet is annexure 3.
Annexure?
Annexure 3, page 18. Which of the sections against me is section 279, 337, 338, 427, 304 A IPC, read with 182 of the Motor Vehicle Act. Now, Your Lordship, if you can see, even my cause title when I had filed this quashing petition, I had reflected the same sections. Also, I'll just place one order to which the learned magistrate had filed the proceeded with the case. Just one order.
Basically you're seeking quashing on the basis of the compromise.
Lordship, there's some development with regards to the sections because all these sections were not framed.
This is a new information.
Yes, Lordship, we were not aware of this.
Yes.
Lordship, we
Let us
won't
just see. Let us just see if required.
Since June 2022.
Yes, Lordship, we were not aware because I was only appointed recently as a state defense counsel.
But then you have filed this case, isn't it?
Yes, Lordship. Then I came
Was
through
it
the
not
case
your duty
record.
to
This
verify
was
it?
filed in 24.
Yes, Lordship. So I'll just take to the relevant page, Lordship.
Just yes. Okay.
Page paragraph 5, Your Lordship.
Yes.
Though the charge sheets have been filed under 279, 337, 338, 427, 304 A IPC, further charge sheet was also filed under 182 of the Motor Vehicle Act against so and so for not possessing valid driving license at time of incident. I do not find section 337, 338 are attracted in much as the pillion rider has unfortunately passed away. Consequently, offence under section 304A is attracted. Therefore, notice is framed under 279, 304 and 427. So, Lordship, some of these sections, that's 337, 338.
Therefore, notice is framed under means?
The trial will be only on these basis.
The charge.
Yes, Your Lordship.
Charge, it should have been charges framed, and I don't know why notice is framed.
Then what is the, if it is altered this way,
Yes, Lordship.
which way this alteration helps you?
Your Lordship, this is just to bring to the notice of the court that when I came to this
Otherwise,
court,
it is not relevant. For
yes,
the
not
court.
relevant, Your Lordship. Just to bring to the notice of this court, Your Lordship, so that
So that means this because of these sections.
yes, Your Lordship.
Okay.
So these two sections, 337, 38, were not framed against me anymore, but only the other sections. Now,
is this correct, madam? This will be
Because this is,
has the charge been framed under this?
I'm not aware of this. This has been brought
Notice
to my
is framed against
notice.
the accused. He pleads not guilty and claims to be tried. What?
We can
What does
seek
it mean?
instructions because I'm not clear on this, and this was way back in 22.
22, Your Lordship.
And this petition for quashing has been filed in 24. It has not been given in the petition, but the charges were framed under these sections. This was heard at one point of time, Your Lordship may recall, and Your Lordship had said that whether the offence under the Motor Vehicles Act can be compounded or can be compromised and all that. That was the query posed by Your Lordship to us.
So, Your Lordship, to that I was coming to that, Your Lordship.
So
Now,
Your
what has
Lordship-
fallen from Your Lordship, the inquiry was whether on the basis of compromise, the sections which are framed under the Motor Vehicle Act 182 can be quashed. So according to my understanding, it cannot be quashed since there's a specific provision for compounding by payment of fine or sentencing. So when we had gone to the trial court to see whether that provision was compounded by way of fine or imprisonment, I find out that section 182 is not related to driving without license. Your Lordship may have the Motor Vehicle Act. I'll just point out.
Anyway, for see, like if it is,
Lordship, that's why
say, like let us, without going into getting involved with the technicalities right now. Just supposing, let us assume that there is a settlement.
Yes.
Now, can this settlement be applied here? But then, see, I think it's better if you take instruction on this.
On this
At least what
order
is the
dated
actual charge frame
16/6.
under this? Again, otherwise there will be again problem. You see, like the charge sheet said one section.
Yes, Your
Correct. And the petition for
Has-
quashing says
yes, and
another.
now this order has
Then
been
this
passed.
order has been come and it's
And
just a
since
just
you
a
have given it
printout.
today.
because this is from the CIS itself. Your
There
Lordship.
is no. We could have got a certified copy, but anyway, Your Lordship, we can
copy.
find out.
Then Your Lordship, I'll also place one more order, Your Lordship, from the trial court, because I was coming to the section 182. The frame under the allegation against me is driving without license. However, 182 is not relating to driving without license. 182 is person driving a vehicle who has been disqualified. So I read this provision, then I informed the trial court that has been framed under the wrong provision motor vehicle. The correct provision is 181. So I filed one application to alter the charge. So Your Lordship, this is the
All
order.
this is
That's why, Your Lordship, that's why before I begin the
new
hearing itself,
development.
before I begin the hearing, I just wanted to place all this.
But
And
then all those things are needed, then they'll have to have.
yes, so
the
that's why I'm
instructions from the-
supplying before I begin
Yes,
with the
let us see
hearing
how
itself.
many orders he has, then you take
You
instruction
have
at
how
a
many
time.
orders?
Just this two.
Just these two.
You have some more.
11/9. No wonder.
Do you have some more surprises for the prosecution?
None, Your Lordship.
This is enough for today.
Your Lordship, under this, the charge has been altered to 181, and thereafter the accused person.
This is 11th September.
11 September. So we have taken
24.
steps because we have been framed under the wrong provision. So we have supplied copy to the prosecution to alter the charge as well. So the charge has been altered, and
But
the
That means this is passed after you prepared this application.
after this. That's why, Your Lordship, I'm placing before I begin my hearing. I'm placing all these facts first.
That is all right. But
After
if
the
your-
charge
if your-
was
if
framed
your
and the
quashing-
evidence.
If your quashing application is pending, why have you got this charge altered?
Your Lordship,
No, and
because,
that too when the
because
case is
when
pending
I
for evidence.
when this matter, Your Lordship, I had filed for quashing, there is no stay. The evidence was proceeding in trial court.
So that means
So, Your
means
Lordship, I had that
No,
liberty.
you see, since you got this charge altered at your own option, you face the trial. There is no question now you'll interfere.
Your Lordship, just for this provision, because it's been framed under the wrong.
This is something contradictory on your part.
That's why, Your Lordship, I'm seeking if Your Lordship insists I would withdraw this and file a fresh quashing petition because there's been certain developments.
See, it is a different thing. But then once you got these charges modified after filing of this petition, that means your stand is wholly contradictory. You cannot grant your prayer in this 482.
So, Your Lordship,
They themselves, at their own option, got this charge altered.
Altered.
Showing their intention to face the trial
Charges,
under the altered
trial before the.
So where is the question of
Your Lordship, because the query which had fallen prior, before I had went to file the alteration, was whether it can be compounded. I had realized that.
So you have adopted a strategy which goes against you now. Probably you thought that
Perhaps
if
the
you get it
court's
altered, you have
permission ought to
proceeded
have been
further.
taken.
Lordship, in my humble
You cannot. You see, once you have invoked the jurisdiction of the High Court, approaching the court, trial court for altering the charge was not a.
Behind the back.
This is
Lordship,
something that doesn't speak of good conduct of you.
Lordship,
Because
I
it's
would.
behind the back. The court
Lordship,
has not been
I wouldn't
informed.
say that it's behind the back of the court since the trial itself was proceeding. And if your Lordship sees the order which under which I had gone.
See, as a counsel, you just tell us, when has approached a higher court for quashing the entire case, was it proper for you to approach the trial court for altering the charge?
Lordship, there may be lapses on my part
That
as
is
well.
not an absence, this is a kind of misconduct. Because, you see, you wanted to create a situation which benefits you.
Lordship, my apologies, but your Lordship, as I stated.
Personally, you have nothing, Mr. Counsel. This court has nothing against you personally. If you say your conduct means your party's conduct. It is not
On
there.
many occasions, your lordship says they have been praying for time.
Now-
Several occasions. Then that was the reason why they had sought for time, perhaps because they were trying to do something else in the trial court.
Probably they thought they will have obstacle here in this
Yes.
case.
So
they tried to remove it
yes.
by.
And then, but we were unaware of it. Neither was the court informed of that strategy, nor the state.
Whether your prosecutor before the trial court has knowledge of pendency of this case.
Lordship, it was informed. It's reflected in the order also, Your Lordship, of the trial court.
That is coming for your statement.
No, I will just.
We want to know
produce
it from
We will have to.
their mouth.
We will have to
Your Lordship,
find out,
before-
Your Lordship, because we
before-
are not aware of all
Before I
this.
approach this court,
You do one thing, you take instructions.
Instructions on these two orders as well as they.
Let them
the
see. Think about it.
cases
This is not a good thing.
so Your Lordship, since I was praying, Lordship, since there's a certain development now, in view of the charge which was not framed against me, and this subsequent development, I had prayed, Your Lordship, if Your Lordship permit me to withdraw and bring all these factual aspects by way of a fresh petition.
Okay, if you want, we will permit you with the liberty to file a fresh. We will
We'll
not
file,
say
we'll
what
file
you
a fresh,
bring
Your Lordship.
and
I
what.
understand every.
Whether that latitude Your Lordship will give after the conduct they have, just.
Lordship, my
shown
humble.
that-
No, you see, if there is a prayer for withdrawal, that is no way basically going to harm you. If they come up with fresh application, you will have your defense.
I leave it to the discretion of this honorable
No,
court.
if
But
you
then,
have any objection, then if you have any objection, then there's the objection. I mean, like on what basis? Just because you see,
because
like
they have not come clean before the court.
Your Lordship, if I had not come
And
clean, I wouldn't
so-
have produced this order before this court, Your Lordship. I wouldn't have been candid with it.
see, Mr. Counsel, repeatedly we are saying that we have nothing against your personal conduct.
No, Lordship,
The manner in which this thing has been done is not very proper.
Lordship, that's why the order was produced to bring to the knowledge.
Will-
Even
will allow
before
them
I
to-
begin with my hearing, Lordship, I am placing this, Your Lordship. I have not even started my hearing.
But even if you file afresh, we have to take care of all those things. Now objections will come from there.
Your Lordship,
We'll allow them to withdraw it, let them
withdraw,
file.
Your Lordship, permit to file afresh, Your Lordship.
Mr. Also, Learned Counsel appeal for the petitioner on instruction submits. The petitioner does not want to press this application and prays for permission to withdraw the same. With the permission to withdraw the matter with the liberty to file afresh.
Should make
In view of the
How many witnesses have been-
in view of the prayer,
Who's the
this present application stands dismissed on withdrawal with the liberty as per.
Your Lordship, may kindly only be reflected that in view of the certain developments with the two orders.
We will not say that. Then she will have objection.
Okay.
It's
Because
up to
these
you.
orders are,
Yes, Lord.
we are not sure because they are not certified copies also.
Because if you say that, then they may have some objection.
Okay.
They will
I think this is enough.
probably, if you show that, then you may have objection.
Yes,
isn't it?
because they are not certified copies. We'll have to seek
Because
instructions on that.
subsequently, if we say that, then you will not be able to raise your objection.
Yes,
subsequent
point out
on the
all
case,
that.
saying that it was known to you.
Apologies,
Think
Your
over,
Lordship.
think over. It is your strategy. The court is up to you. If you want to proceed with it, you can do it.
Your Lordship, proceeding with the trial since the party has a compromise also is another question, Your Lordship. Will not serve
Now,
the ends
you
of
see,
justice.
your compromise was attained. Now many things will come before this alteration of charges.
Yes, Lord.
So you will have more difficulties. Anyway, all right.
Tender my apologies, Your Lordship.
But you should be careful to see. You are a
Understood.
young man. You should not give an impression to the court that you are now you're like playing some tricks. See, once a counsel loses the trust of the court, then there remains nothing for you.
Lordship, everything was done in good faith, Your Lordship, applying my wisdom.
See,
See
this
the
court
matter.
was on the other side for about 3 decades.
Yes, ma'am.
I'm speaking from my experience. What matters most is that the trust of the court. Right? That is the most precious
Yes,
position of a lawyer.
Thank you,
Obliged,
Lord.
Your Lordship.